So we're now recording. Hello, everybody. This is Elena Garrett, and today this is a podcast with Elena, and today I have a very special guest. We're going to be discussing legal aspects of rent-to-own agreements in Texas. Rent-to-own is something that generates quite a bit of confusion and controversy. So I thought that it would benefit everybody if I brought in a legal expert. So today with us we have Sade Ogunbode, and she's an attorney at law. She practices in Austin, Texas, and she gracefully accepted my offer to help us to understand some of the nuances of what makes rent-to-own so confusing and so difficult for people to understand. So today is going to be part one of our podcast because there is so much to cover about rent-to-owns. But let's go ahead without further ado, jump into what we can discuss about rent-to-owns in our podcast. So I'm hoping that within the next one or two releases of my podcast, we will be able to cover specifics of rent-to-own or lease with an option to buy or several other variations of that agreement in Texas, the most common issues with rent-to-owns in Texas, the misconceptions that people have about rent-to-owns, and then we're going to top it off with the advice for both consumers and landlords that might be considering rent-to-own as a good way to move forward. So let's go ahead and start with understanding the basics of the rent-to-own, and that is kind of the devil is in the detail, as it always is with legal contracts. So let me see if Sade can enlighten us on what makes rent-to-own so difficult. What is the difference between lease option and lease purchase, and how do we navigate toward a successful rent-to-own?
Okay, those are great questions. So I'm looking at this, the bullet points to guide me. So when you talk about contracts, most times one side is giving something in exchange for something else. And with real estate deals, we're giving money in exchange for title to that property and also usually possession at the same time. So an executed contract is fully done. That means all those things that were supposed to happen already happened at the time of the closing.
Can you give us an example of an executed contract?
Executed is when I approach a seller as a buyer and I offer them $100,000 for their home, and then they go ahead and accept $100,000. We sign the contract, but at the time of closing, they get money and I get keys to the house, but I also get title. So that's fully executed because there's nothing else left to be done.
Okay.
Executory contract, executory, you hear different ways of pronunciation. Don't worry about it. As long as it has the ORY at the end, that means it's not fully done yet. It's still pending. So something is still dangling out there. And typically the thing that's dangling with the real estate transactions is the actual transfer of ownership. So let's say I'm a tenant, I'm doing what I'm calling a rent to own. I might be inside that home, but I don't actually have my name on the title. So that means it's still hanging out in the future. And they're all different types of them, but they're all typically owner finance deals when you think about it. So lease to own is a type of owner finance deal.
Okay. So executory,
executory.
Executory.
I don't know how to pronounce it either.
Right. Executory contracts is something that what we have to deal with when we enter the rent-to-own territory, right?
It cannot be completed right now, so there is the final performance is in the future. And there is a rule that's very strict regarding those types of contracts because a lot can happen between point A and point B. And the laws against those types of contracts, it's because of predatory lending issues that happened in the past. And a lot of sellers / landlords, they were actually giving those contracts to people that couldn't afford to buy the home. So they would intentionally collect rent and then some.
And so they would collect rent with no intention to sell, right?
That's right. They knew that that party would never be able to buy it. So they essentially just sold it over and over and over again to several tenant buyers.
Okay, so that predatory behavior resulted in a few changes in Texas legislature, which is why so many people stopped doing rent to own. So could you enlighten us on what changes took effect, why they're so restrictive, or we know why they're so restrictive, what the restrictions really are, and the details that the options that people now have?
Okay, well, I'll run through them really quickly. And
Mhm.
so the laws changed in 2005 originally to regulate more um, as far as how people could go about doing these types of contracts that are dangling. You know, they're not fully completed. And then there was additional changes in 2017. So the overall thing that you need to worry about, because it's a gazillion things as far as requirements go, is that the Dodd-Frank Act is implicated in these transactions because it forces you as the seller landlord to make sure you qualify the buyer before you ever even sign anything with them. So you can't.
So somebody comes into me and say, I have $2,000 and I want to start the rent to own. And I'll say, that sounds like a good deal. Where your $2,000? The Dodd-Frank Act could possibly get me, right?
That's right. You need to show that you've qualified me just as a regular lender would do. So you need to look at my credit history. And sometimes my credit history is not great, but at least look at my income, if that's the case. And look at what plan I have to fix my credit history or profile. So that's one thing. And then the SAFE Act was already in place because of the big banks and all the other lenders doing predatory lending. And so it has to do with mortgages, and it specifically is on the federal level, but Texas has a version of the SAFE Act, which is to do with enforcement of mortgages. And because remember, the landlords that were sellers, they were kicking people out intentionally and reselling those properties over and over. So the SAFE Act asks you to be licensed if you're going to be doing several deals in a year. And so you either are using your homestead, which is your primary residence, for this type of a deal. In that case, you don't need a license at all, or you're selling it to a family member. In that case, you don't need a license if you do a lease to own with a family member. If you're doing more than 5 transactions in a year, you must have a license according to the Texas SAFE Act. It gives you an exception based on the number of transactions, essentially. It's telling you it doesn't have to be your homestead as long as you don't do more than 5. Then you don't need a license.
What kind of license? Did the mortgage originator license?
You need a license as a lender, essentially.
Okay,
the requirements are also out there, but the lawyer, this is why it's important to consult with a lawyer if you are going to be doing this as an investor, because how many are you realistically doing in a year? You need to worry about those types of requirements. And I wanted to quickly answer your original question about what is a lease option and why is it different from a lease purchase. In real life, they're not really different in the way that people use them because people combine them all the time. So a lease option in the pure form means that I took out a lease on a piece of property, and I, at the same time, also purchased an option. So I haven't yet agreed to a price. We haven't talked about all the details. I just purchased an option sometime in the future. Maybe I might buy it. A lease purchase comes with a contract already for a determined price. So those are the main differences, but you can see that they're usually used together because most times people have an option and then they also have an agreement as to what's going to take place in the future, which makes sense because you want things to be predictable.
Correct. So if I, for example, discuss with a particular, let's just say that I represent a renter, and that renter is interested in doing rent to own, and they like this property at $100,000, it's currently in the market, that's currently being leased out, and they agree that within 2 years they're going to buy it at $120,000, right? So at this point, since we already negotiated the price, we're entering the hybrid territory, right?
Absolutely, yeah. It's definitely a lease purchase because you're saying that you have an option to buy it, but you have all the pricing and everything. And in the legal world, in all reality, it's an obligation when it's a lease purchase because I'm promising that I'm going to do it. But because of the property code that we have here, it's very much pro-buyer, pro-tenant. So the tenants can usually back out. Yeah.
So now a lot of people call me and say, I would like to do a lease, I would like to do a rent to own because I have renters who've been living in my property for 5 years and now they're interested in buying it. And they say, I've heard something about the 6 months rule. What did that mean? Can you explain to us the 6 month rule?
All right, so the 6-month rule is an exception to the rule of those executory contracts. So the executory contract is unambiguously anything that's longer than 6 months that combines a lease with an option to purchase it in the future. So anytime you have those types of transactions, the law says you have to follow, I don't know, like a million steps and follow a lot of things, and it has all sorts of rules. So that's the rule. And then the 180-day thing is an exception to that rule that says if your lease, however, is going to be shorter than 180 days or no more than 180 days, you can go ahead and do that kind of a deal without necessarily falling under the main rule. So that allows you to bypass the main rule and not get into trouble. And some of the requirements, they're difficult to cover in a video because there are tons of them, but some of them have to do with all the disclosures that you have to make and also the kind of accounting you have to provide. However, some of those requirements, they're strictly applied, meaning that let's say I forgot to give a disclosure, I didn't do it intentionally, it's still considered misrepresentation or deceptive.
What happens if there is misrepresentation?
And then that allows the buyer tenant to actually cancel the whole deal, which maybe they really wanted to cancel because they changed their mind, they got cold feet. So they can then cancel the whole deal and get all of their money back, including whatever down payment, whatever rents, whatever option fees, whatever they fixed in the home, that's a major repair. So you get to pay them everything back. And then if they feel that you did certain things, maybe they're disgruntled with you as a landlord seller, then they do tend to take you to court. I've seen them do that sometimes. And then they're allowed to get triple damages, meaning ×3 of everything that I just mentioned.
So this is a big danger, right? So if you are using a 180-day rule, let's just say, let's just say that let's run it as an example. I have this tenant been living in my property for 5 years. Now they want to enter rent to own, and they need 1 or 2 years to get their financials and credit together. If I go ahead and don't, so what if I don't provide them with any paperwork? We'll just say, okay, here is a bill paper that says, within a few years you can buy 120. This was the only disclosure that I gave them. How would I utilize the 180-day rule? Can I give them 180 days to resubmit that contract to them over and over again, or how are we going to do it? So I don't have to give all the disclosures if I don't have them already.
How do you do that kind of a transaction to give them 1 or 2 years to get everything together without having to follow the rule per se? Is that the question? Yes,
kind of. Yeah. How can we harm the six months?
I think it depends on the artistry of the lawyer involved, honestly. Okay. But you really could do a right of first refusal for a year or a year and a half, right? You could do that, because if you do a right of first refusal, it's not exactly an option to purchase that comes along with a lease. So let's say they're already in your home for 5 years, you could then extend their regular lease that they already had and get a right of first refusal. And the right of first refusal says that if you are ready to sell that home as the landlord, they get the first chance to buy it from you. But of course, because you already have an agreement with them, you allow them to renew that right of first refusal, okay? So typically there's a clause in there that says if the landlord would get a higher offer than what they would have normally paid to purchase that property, then the landlord either goes with that new offer or they have to match it. So you might want to negotiate that out of your right of first refusal and just keep it at a fixed price in the future or at market value. which will be determined by maybe 2 appraisers, one from the side of the landlord and one from the side of the tenant. So you could do a right of first refusal for a little while and then do your 180-day lease if you still need more time to go ahead and convert it to a lease to own at that point. So
Okay, that sounds like a very complex process. So if I, as a landlord, wanted to do that, what would be your best advice to me? Because that sounds logical until you actually try to do it, right? So what
right. I think you need a lawyer for all these types of deals, in all honesty, because they're just more nuanced than a regular transaction that can be done with a TREC form. So you need a lawyer to look at actually to put together the right of first refusal in a way that it honors the intentions of both sides. And you also need a lawyer to then review the lease to make sure it's good to go, whatever that lease looks like, and then build into that right of first refusal the chance to purchase an option, a lease to own option at the end of it all. So that's how I would do it, so that it's not stacking per se, but it's giving the tenant a year or 2 to get the finances together, the credit profile, in the right place before you actually trigger this rule that has to do with executory contracts.
Now, question to you. If I had some clients from a real estate agent, if I had some clients who were currently considering entering into this rent-to-own business, more or less as a consistent business line for them, would you be like, they wouldn't need to, you wouldn't recommend using a TREC contract? Could I send them, for example, to you and you help them to put together these contracts?
Yes, we can help with these types of deals, of course. And if you're in another state, maybe you're just watching this podcast, you should talk to a lawyer in your state. But we can help with Texas transactions for sure.
Okay. Sounds good. Thank you so much, because I don't think that, and I was looking at how to structure that deal with my own limited knowledge of, contracts in Texas, and I was racking my brains how we're going to write it all out. So yes, so this way we can step away from a TREC contract and just hand the entire contract off to the lawyer and say, write it from start to finish, right?
Yes.
But when they're actually buying it at the end, do they need a TREC contract then when they're actually executing the actual purchase?
Yeah, at the end, you still need to do a closing, because remember, this is an executory contract. It's still pending. The actual closing is pending into the future. There's a chance that the tenant actually does not buy that property, and there's a chance that they do buy that property. So who knows? So if they do end up buying the property, you still would follow the normal procedures. You have to disclose to them about title company, that they can get title insurance. So you would follow all those normal steps, and a lawyer will probably be involved, or the title company at the very least.
Gotcha. Well, we're actually all out of time. I see that it's almost to the top of our 20-minute segment. So I really wanted us to cover DV homes today because it's a very curious model. And I'm currently involved with DV model, and I was so eager to get your take on DV homes. But because of the time limitations today, let's postpone the discussion, and we're going to, next segment, I would imagine going to happen next week. Let's look at DV home, because so many investors who might tell about DV homes model, they say this is what they want to follow. And I want to understand it myself so I can help them, and maybe, you can help them a little bit more. So with that said, today our guest was Sade Ogunbode, she's an attorney law. She practices in Austin, Texas, and throughout the entire state of Texas, of course. If you want to contact her, you can go to everymanlaw.com. I'm going to put her contact information in the description below. Please don't forget to click like and click subscribe. And also I'm going to point you to Sade's own YouTube channel. This is how I found Sade, and I was really impressed with the YouTube video that she's putting together. So I'm going to give all the information that you can contact her directly with any questions that you have about this kind of contracts. Thank you very much, Sade. I truly enjoyed having you on the show, and I'll see you next time.
Thanks, Elena, for putting this wonderful podcast together. Great work.
Thank you. Appreciate it. See you later. Okay, so we should now be stop sharing, stop sharing, and I'll finish the recording. So